A new wave of court rulings just changed 9 gun laws, and almost no one noticed. And if you still think the rules from last year are the rules today, you could walk straight into a charge you never saw coming. Quick question before we continue. Are you subscribed? Because what I'm about to reveal could keep you from making a mistake that costs you your rights, your money, or your freedom. Hit that button now. Here's what just happened. Courts did not just tweak one tiny gun rule. They moved the ground under 9 major areas that affect regular people. People who carry every day. People who buy from a gun store. People who build a kit at home. People who travel. People with old records. People who thought, I'm a law-abiding gun owner, so none of this is about me. That is exactly how people get blindsided. First thing, the Supreme Court said the government can disarm someone who is under a domestic violence restraining order. This applies if a court has found that person is a real threat. That matters because a lot of people thought the Bruin case meant almost every gun restriction was about to fall. Not true. This ruling told lower courts very clearly that if a judge has found a person poses a credible threat, that person can be barred from having guns. That person can be barred for as long as that order lasts. Let me explain why this matters. If you're in the middle of a messy breakup, family fight, or custody case, you cannot treat a restraining order like just paperwork. In some cases, that order now clearly ties into gun possession. Here's what most people get wrong. They think, I haven't been convicted of anything, so I'm fine. Not always. A qualifying order can still trigger a firearms ban. Second, the bump stock rule changed in the other direction. The Supreme Court said the federal government went too far when it tried to treat bump stocks like machine guns under the current law. That shocked a lot of people, because many assumed that fight was over years ago. But here's the crazy part. The court did not say bump stocks are smart, safe, or protected in every state. It said the federal agency could not stretch the words of the statute past what Congress actually wrote. In simple terms, the court said, if lawmakers want this banned, lawmakers need to write that ban. So if you own one, or used to own one, do not stop at federal law. Your state law could still be much stricter. Third, ghost gun kits are no longer living in that gray fog some people relied on. The Supreme Court also said many weapon parts, kits, and unfinished frames can be treated like firearms under federal law. This applies if they can be quickly turned into working guns. That means serial numbers, records, licensed sellers, and background checks can come into play. Imagine you're buying what looks like just parts online. Most people think parts are parts. But the truth is, if those parts are close enough to a working gun, the law may now treat them like the real thing. That is the part nobody was talking about at the gun counter. The label on the website does not control the case. The legal test does. If you're finding this helpful, imagine what you'll learn in my next video. I will share the exact words that can protect you when an officer asks about your firearm during a stop. Subscribe so you don't miss it. Now let's get into the age rules, because this is where it gets messy fast. Fourth, one federal appeals court said licensed gun dealers cannot use the federal under 21 handgun sale ban in the way they used to. This applies at least in that court's region. In plain English, that court said adults ages 18 through 20 still have Second Amendment protection. The government did not prove a strong enough historical reason for blocking handgun sales by federally licensed dealers to that whole age group. Sounds huge, right? It is. But wait, there's something even more important. That does not mean every 18-year-old in America can now walk into any gun store and buy a handgun. Court rulings often apply by region, and other courts can disagree. So if you are in that age group, or your son or daughter is, do not assume one viral headline equals nationwide freedom. Fifth, Florida went the other way. A different federal appeals court upheld Florida's law blocking firearm purchases by people under 21. Let that sink in. In one part of the country, courts are saying age-based restrictions may go too far. In another, courts are saying some age-based restrictions fit history well enough to stay. This is exactly why copying internet advice from another state can be dangerous. Most people think gun law is national. It isn't. A huge part of it is local, regional, and changing. Here's a hypothetical example to explain this. Imagine 2 20-year-olds with the same clean record. One lives where a court just struck down a sales restriction. The other lives in Florida. Same age, same background. Totally different answer. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. Sixth, the old idea that any felony, or even any old offense that counts like one, automatically wipes out your gun rights forever is getting challenged. In one major case, a federal appeals court ruled that a man with a long-ago nonviolent fraud offense could keep his rights. The court ruled he could not automatically be stripped of his gun rights under that law, at least based on his exact facts. Let me be clear, because this is where people get in trouble. The court did not erase the felon in possession law for everyone. It did not open the jail doors and say, everybody gets their guns back. It made a narrow as applied ruling. That means the court looked at that one person, that one record, and that one set of facts. Still, it is a big deal because it tells you the courts are now asking harder questions. Was the old crime violent? How old was it? Does the government really have a historical reason to disarm this exact person? That is a very different conversation from what many gun owners heard for years. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the gun owners who get these updates before the headlines catch up. Click subscribe. Now this is where things get even more interesting. The next 3 changes hit people who thought they were nowhere near the edge of the law. 7th, courts have started narrowing how the federal gun ban for unlawful drug users can be used, especially in cases involving marijuana. One federal appeals court said the government cannot just point to someone's general or occasional drug use and call it game over. The court said there has to be a much tighter link between the drug use and the gun possession. It needs to be more like active or recent intoxication, not just a vague claim that someone uses from time to time. This is huge because many people live in states where marijuana looks legal under state law, but it is still illegal under federal law. And those people often think, if the dispensary is open, I'm safe. That is not the rule. Here's what most people get wrong. State legal does not always mean federal legal. So yes, some courts are pushing back on broad federal prosecutions, but this area is still dangerous and still changing. Do not treat one good ruling like a permission slip. 8th, California's magazine law came roaring back. A full federal appeals court upheld California's ban on magazines holding more than 10 rounds. That shocked a lot of gun owners because many thought that fight was already won. It wasn't. The lower court had sided with gun owners before, but the larger court reversed that and said the ban can stand. So if you live in California or travel there or store gear there, this is not some debate for legal nerds. It affects what you can possess. Imagine moving boxes after a relocation, finding an old magazine in a range bag, and thinking, this is just normal equipment. In some places, maybe. In California, that assumption can hurt you. 9th, New York's carry restrictions mostly survived, even after all the noise about Bruin. This is the part that shocked me. A lot of people believed Bruin wiped out New York's aggressive response law. It didn't. Most of that law stayed standing after later court review. New York still kept many sensitive place restrictions, meaning areas where carrying is banned even if you have a permit. But 2 parts ran into real trouble. The state's default rule that treated private property open to the public as off limits, unless the owner gave clear permission, was blocked. And the social media disclosure rule for permit applicants also stayed blocked. Why does that matter to you? Because carry law is no longer just about whether you have a permit. It is about exactly where you stand, what signs are posted, and what your state demands. Most people think permit equals carry. The truth is, permit plus location plus state-specific rules equals carry. So step back and look at the pattern. 1, courts are allowing some disarmament laws to survive when the government can show danger. 2, courts are killing agency shortcuts when agencies try to rewrite criminal law on their own. 3, courts are split on age limits, carry restrictions, and who can be disarmed based on status alone. 4, the same person can be lawful in one place and exposed in another. That is the real story. Laws move fast, faster than most people think. Subscribe now because the next video breaks down traps that catch good people in 2026. Here's the bottom line. The biggest change is not just one court ruling. It is that gun law now changes by issue and region. If you buy, carry, build, or store firearms based on what used to be true, you are taking a risk you do not need to take. So do yourself a favor, subscribe, stay updated, and send this to one friend who still thinks gun law never changes. It does, and it changes quietly. And one last thing, this video is for education only. It is not personal legal advice. If your freedom or your gun rights are on the line, talk to a qualified attorney in your state before you act.